Hello, everyone. Welcome to Another Day in the Car. I'm Jules, and I've got insomnia. So I've been reading the documents again that were recently released in the Barry Morphew case. And of particular interest are the documents that are related to the contempt regarding talking out of turn on the part of the prosecution and law enforcement. The complaints have been in place since Barry was being represented by a public defender's office, and then his dream team ladies came and renewed the complaints and then continued filing more complaints. We should start with the arrest warrant, in that DA Stanley stated that she wanted it sealed because she was afraid of a flight risk. She thought that Barry might be leaving, and she said that she had heard or had information that he had taken his Bobcat to Indiana and that there was noise that he might be going to Arizona. But when he was arrested, his Bobcat was over there near that condo that he was living at and where he was working. That comes into play later because that's some information that she then shared. According to the order that was in place since June regarding what people could say or not say in the case, and the judge was saying, I shouldn't have to say this, but because I believe everybody's going to act ethically, but I'm going to spell it out anyway. And he says that, the parties, the lawyers and stuff for the parties, that includes law enforcement, etc., shall not, from the filing of the complaint, the issuance of an arrest warrant or an arrest, until the commencement of the trial or disposition without trial, make or participate in making extrajudicial statements that a reasonable person would expect to be disseminated as a means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter that relates to 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or a witness, or identity of a witness, or the expected testimony of a party or witness. 2. In a criminal case or proceeding that could result in incarceration, the possibility of a plea of guilty to the offense or the existence of or contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement, and the performance or result of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Any opinion as to the guilt or innocence of a defendant or a suspect in a criminal case or proceeding that could result in incarceration. The information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Or the fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. That's pretty straightforward. And then I can see where some of these complaints have come out, because this stuff has been sealed since the arrest warrant, but the information has been coming out, and law enforcement wasn't supposed to talk about anything like Barry's refusal to do a polygraph, or when he wasn't talking to them or wasn't cooperating, or information about what was or was not at the property, like ice chests or anything like that. And we know that all that got leaked out. And this is just something that's going to have to be decided on by the judge, because I really don't understand exactly the letter of the law, but it does look like maybe some lines were crossed. And then afterwards, after he was released on bond, it appears that there were some behaviors that could continue to be like contempt type stuff. People's motion to modify bond conditions. The people have been made aware that the defendant has proposed that he will live at a vacant residence frequently used as an Airbnb or vacation rental at 10987 Puma Path Drive, Marysville, Colorado, in the Monarch Estates subdivision, the Cushman residence. The people request the court enter an order that would prohibit the defendant from residing at that location for the following reasons. A, the Cushman residence is only a few hundred yards away from 10957 Puma Path residence. The people have requested the defendant be ordered to stay away from the Puma Path residence. The Cushman residence is in the same neighborhood and is near the Ritter residence located at 10969 Monarch Drive. The Ritters have been very clear that they do not want to have any, and they got any in all caps, contact with the defendant. Therefore, if the defendant is allowed to reside in their neighborhood, this will undoubtedly make the Ritters at the very least uncomfortable, and possibly not wanting to continue to reside at their home any longer. And D, if the defendant resides at the Cushman residence, he will undoubtedly find it difficult, if not impossible, to abide by the orders of the court. 3, the people have every reason to believe the defendant is paying rent at a residence in Salida, 315 Poncha Boulevard, near the courthouse. It makes sense for the defendant to reside at this residence instead. Respectfully submitted, Linda Stanley. The response from the defense. Court is aware Mr. Morphew did not have a residence in Chaffee County as of September 20th, 2021. Mr. Morphew requested to reside at his daughter's residence in Gunnison, Colorado. Fortunately, Mr. Morphew's friends and former neighbors, the Cushmans, offered to allow Mr. Morphew to reside on their property in Chaffee County in a rental unit. Mr. Morphew does not have a better option for a residence in Chaffee County. Contrary to the DA's belief, Mr. Morphew does not pay rent at a Poncha Boulevard address, nor has he ever spent the night at that address. The address is Shoshana Darks. The court should not order Mr. Morphew to live at an unrelated woman's home whom the DA's wrongly implied he had an affair with before Suzanne disappeared. The defense has great concerns about Mr. Morphew's ability to obtain a fair and impartial jury when he and the criminal allegations are well known to most of the residents of Chaffee County, whom Mr. Morphew is required to live amongst. Upon information and belief, DA Lindsay and FBI Harris have recently contacted parties and witnesses involved in this case and encouraged them to read the arrest affidavit as proof that Barry is guilty of murder in the first degree, attempted to or did scare witnesses into believing Barry is dangerous and they need protection orders from Mr. Morphew, and attempted to convince the homeowners where Mr. Morphew is currently living to kick him out, and advised them that since Mr. Morphew had enough money to bond out, he has enough money to rent a hotel room for the duration of the case. As instructed by the ABA, Criminal Justice Standards, Prosecution Function 3, blah, 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 the prosecutor or the prosecutor's agents should not act to intimidate or unduly influence any witnesses. The court should not entertain the prosecution's motion to modify bond conditions because it is unjustified and unreasonable. Additionally, it is apparent that they may be in violation of the Colorado Rules of Professional Conduct and the ABA Criminal Justice Standards by creating this irrational fear with essential witnesses in the case that Mr. Morphew is a danger to the public while he is on bond, and attempting to convince them that Mr. Morphew is a murderer. Yeah, it appears that there is communication going on, and that it might be communication that would be prejudiced against Barry, and yeah, that's it for now, and I'll see you in the next video. I look forward to your comments. Thank you for watching Another Day in the Car with Jules.